No, other than the fact that I believe the only evidence that they have in this case too is the uncorroborated testimony of the victim in the case, Judge, as far as I know. So that's the only thing I would add.
Okay, all right. Mr. Wallace.
I shot Judge now, huh? Judge, I'm not going to sit here and reiterate what Mr. Green or Mr. Navy has harped on. For judicial comment, I'm going to get to the point as it relates to my client. My client has no felony criminal history, very minimal misdemeanor history. He's a lifelong resident of Lincoln County. He was gainfully employed before his incarceration at Lincoln Leasing. It's a mining outfit, and he's still got his job. It's waiting there for him if he gets out. He has no problem with the no contact requirement as it relates to the victim. I think my client has some kind of romantic history, very, very briefly, with the alleged victim. Judge, we believe that this was somewhat of a random act. I think there wasn't a history of these people knowing each other, but we believe that the two-prong requirement, that one is that he make all his court proceedings. He turned himself in this particular instance, found out that there was an arrest warrant out here. He turned himself in to the law enforcement. Secondly, that he not to commit any other offenses. Judge, I think you'll have no problem with Mr. Cummings as in that regard. We believe the bond's excessive, and even in light of the facts most favorable to the alleged victim in this case. Judge, we're just asking for some reasonable bond. I think my client can make an approximate $25,000 property bond, which would be reasonable, like I said, in light of the facts, even given what the alleged victim says in this case. So we're just asking for a reasonable bond, let my client get back out and get back to his job. And if the court sees fit, my client would even agree to potential home confinement as conditions bond.
Okay. All right. Mr. Prosecutor, any response?
Again, no, not really, other than just to reiterate what I've already said. And I do note that there was at least one statement from somebody that states Mr. Cummings got a weapon off them that potentially was used in the crime. But other than that, again, I don't disagree. I've known Mr. Cummings since I've been a prosecutor. I'm not saying that to talk about it. I mean, I know that because I know he is in fact a lifelong resident of Lincoln County, at least in the last, as far as I know. So I'm not going to disagree with that. And again, I just reiterate the other arguments that I had. They all, really used to rehashing what I said in relation to Ms. Bragg then, because they're all the same. So I'll leave it at that.
Mr. Wallace, any response?
No.
Okay. Well, syllabus point 1, Hudson v. Dostaire is a case-by-case determination of the right to and amount of bail in criminal proceedings is consistent with the Bill of Rights provision that excessive bail shall not be required and with the discretion vested in the courts under West Virginia Code 62.61. All right. And given the circumstances as outlined in Hutzler, goes back referencing State Ex Rel Gibbs v. Johnson. Now, there are a number of factors that are set out in State Ex Rel Gibbs v. Johnson. Number 1, past criminal conduct, any failures to appear in the past, did the accused surrender or flee or attempt to flee? Is there a fresh arrest? Has there been a preliminary hearing, or is there an indictment? The nature of the crime charged. Etc. Now, one of the things that I have heard is reference to criminal histories. And I think it would be proper for the court, before it makes any determinations here on this bail, to review the criminal histories. Has there been an NCIC or a CIB report generated in regard to the defendants in this case?
I'm sure the officer's done one, and they generally submit that to me when they submit the police report, and I don't think you have a police report. I would assume most of criminal histories would, again, they have been lifelong residents of Lincoln County, so my guess is, Your Honor, that criminal histories largely, if not all, lie within the bounds of Lincoln County.
Okay.
I've been prosecutor here for 13 years. To my knowledge, I haven't indicted any of, Ms. Porter, I think I did indict, I believe there was a felony child molester. I believe she has been indicted. It's been so long ago, I don't recall how that case turned down, if it was played down, because I know there was a companion abuse and neglect case, and I think we handled that kind of universally, and I don't remember what the final results of that were, but I don't believe she pled guilty to a felony. To my knowledge, I've not indicted Mr. Bragg or Mr. Cummings. You know, they've been in magistrate court on, both of them have been in magistrate court charged with various offenses on numerous occasions, but again, I've been, at least in the 13 years I've been here, I don't recall that Ms. Bragg or Mr. Cummings have been indicted by felony means, and I would think if I had, I would remember it. So my guess is neither one of them, to my knowledge, has a felony conviction. And I think Mr. Green pretty well summed it up, but and probably in regards to both of them, they've been in magistrate court both quite a many times. And I reiterate the fact that Ms. Bragg was on 2 bonds at the time, and I understand Mr. Green's position on that. But again, I think that, again, I don't have the actual criminal history, but that kind of summarizes it up the best as I know from my 13 years here as prosecutor.
Okay, let me ask, do any of the parties take objection to the courts taking judicial notice of whatever's in the criminal histories here? Mr. Prosecutor, do you have any objection? I'll take judicial notice. Mr. Green, do you have any objection?
I suspect the court already knows that from another case that I'm involved in here, because I think you had that record pulled.
Well, okay, I may have.
I think, and but of course, my only comment to it is, again, I would try to stick to the point that the fact you're charged and they dismiss it is one thing, and the fact that they may come around and charge you again, because to be very frank with you, I've felt many times that my client was picked on in this county. And so there's things occur that maybe ought not occur. There's one pending now where I have made a motion to dismiss because I really don't believe a 16-year-old DUI qualifies to enhance penalty.